Well, I think the American Law Institute does very important work. Law is difficult, and even the concept of what law is difficult to get one's head around. Is law just a tug of war back and forth between the competing elements as to any subject? Lenders as opposed to borrowers, landlords as opposed to tenants, in copyright owners as opposed to users? Is it just a tug of war in which it goes one way then the other way, back and forth? Or is there some kind of a Platonic ideal of a neutral law? We have in the American Law Institute, we say that lawyers should leave their clients at the door and come to American Law Institute meetings with the intention of trying to produce an ideal, neutral characterization of law. And that's very, very difficult to do, but very, very important. Well, the process is one of discussion. The process is one of getting excellent reporters to prepare texts that, in the reporter's view, states what the law is and explains the law, and getting, as you say, a multifarious audience of co-participants who will examine it, critique it, take it apart, offer their views, argue about it, talk about the substance, with the objective of eventually producing a draft that clarifies law neutrally stated, not with a view to trying to help one interested segment or another interested segment, but with a view to represent the law accurately from a neutral point of view. In undertaking to prepare a restatement, the reporter is undertaking as a scholar to study all the sources of law, statutes, common law, the court decisions, regulations, everything that's involved, and to produce an accurate reflection neutrally viewed of what the law is. And that is what renders it useful to the world of law. The criticism that I have often heard made by some of the members of the advisors committee and consultative group is that because there is a copyright statute, there is no need for or no appropriateness to a restatement. I think this is completely wrong. I think it makes no sense whatsoever. The statute, of course, is the law. One cannot present a restatement that is giving a different law from the law given by the statute. But the statute is a very complex composition of different elements. So the statute zigzags back and forth, sometimes from clause to clause, between instances where Congress is taking the reins in its hands and dictating policy and specifying exactly what the law will be. There are a lot of provisions like that. And numerous other provisions, especially those that address the very fundamental concepts of copyright, where Congress in the statute is stepping back and merely approximating the result of decades and even centuries of common law development, with the understanding and the expectation that that common law development will continue. So that the statute is not freezing the law, saying this is the law. It merely undertakes to, in a capsulized way, in an approximative way, say, this is what we understand this doctrine of law roughly to be. But courts are going to be going on to explain it and develop it. And so to say that because the body of copyright law is statutory, there's no need for or no appropriateness to a restatement. That's just completely wrong, because to understand what the statute is saying, as to many instances, you need to understand the common law development which the statute is incorporating by reference. We'll take Section 107. Section 107 of the Copyright Act deals with fair use. So what is fair use? The statute doesn't really undertake to define fair use. It contains an approximative reference to an 1841 decision by Justice Story, and sets forth 4 factors that were mentioned in the Judge Story opinion. So fair use has undergone huge transformation. First of all, it emerged, it was born in court decision, and it has continued to develop in court decision, and it's been enormously transformed by the Supreme Court's 1995, I think, 95 decision in Campbell against Acuff Rose, which has clarified what fair use is in a manner that never was done before, and has opened the door to different kinds of understanding of fair use. Well, you can't understand that from the words of the statute. It's only reading the common law that will explain it and make it comprehensible. And so, for many issues like this that are fundamental doctrines of copyright law, the statute isn't going to give you the answers. You need to understand the common law development, and that's one of the things that the restatement undertakes to do.